Okay, so you can hear me okay? Oh, I want I want a different camera though. Different. It's not recognizing my camera. All right, we're live. So I had everything all ready, and then I moved. I tried to switch sides of my office, and now my external webcam didn't work, and my microphone either. But all right, well we'll go ahead and get going. So this, can you hear me okay, Derek?
Yep, I can hear you just fine.
Okay, so we're live on YouTube right now, and then this will be in Pace's Creative Finance page.
Okay.
And so I got your email. Thanks for reaching out. So you're in Pace's group,
Yes.
and you said that you need some help with a probate issue. One of your clients, you have a property under contract. Is that true? And then the owner's deceased.
Yeah, that's right. So
Okay.
so yesterday I got a contract, a house on contract. The owner of the property is deceased. The seller is telling me that the owner of the property, when they died, that they gave the house to her mom. And her mom, when she died 2 years ago, willed the house to her. So she said she has all the legal documents showing that the house was willed to her. That it never went through a probate, but she said there's no other heirs that will contest uh, her selling the house. So she never took the house through probate, but she said that she's on the will as the heir of the property.
Okay. So here's the steps to go through. So here's the outline.
Okay.
So I'm going to make this available as a download on montlegal.com. And then I gave this away to Pasted a Mastermind. So I've used this tool before in other pieces, but I realized this is a perfect tool for real estate investors. Now, what I taught at the Mastermind, we went over probate. And what I want you guys to do as the wholesalers and real estate guys out there, real estate investors, is I want you to bring the leads to the attorneys. So attorneys like doing legal work,
Okay.
and you guys like doing deals. So let's talk about the steps to go through. So this is the way I deal with it. So this is outline for successor trustee and or personal representative. I got my equipment kind of all over the place. And all right, so what are the assets? So I guess really the main thing you're concerned about, and I don't know the rules in Oklahoma. I'm an attorney in Arizona and California. I'm licensed in Nevada, but I'm inactive there. But so the steps are, so the assets, you've identified that there's a house there, right? There's a house in the name of the deceased.
Yes.
The second part is determine players. So decedent is the dead person. Fiduciary is who's in charge, and then the beneficiary, who receives. And then in order to determine those, what controls. So your situation, it sounds like, so the property is titled in the name of the deceased. Is that the title still shows the name of the deceased person?
Yes, that's correct.
Okay. Did they have a last will and testament? Do you know? That's what you need to figure out.
Okay, so I don't know about the deceased who the house name is still in, but I know that the seller's mom, the initial deceased who's the name the house is still in, willed the house to her mom, and her mom willed the house to her.
Okay, so did two people die?
Yes.
Okay, so there may be what we call it double probate. So we got to go out of the name of the first deceased, and figure out where that goes. So that's where I want you to start. So the name of the title, figure out what's controlling their estate. So if they had a last will and testament, that will be controlling. If there's no will, look up the laws of intestacy. So you're in Oklahoma, you said?
Yes.
So Google that. So Google Oklahoma laws of intestacy.
Okay.
Intestacy means no will. So if there's no will, the state law determines the beneficiaries and who has priority to serve as the personal representative.
Okay.
So that's what you have to figure out. So who's got the control? Let me pull up some of my other materials.
According to her, she said that she has all legal documents showing that, the house was willed to her, and that she has the death certificates, and there's no other heirs to contest her selling the house because no one wants anything to do with it.
Okay. So have you you're going to want to find a probate attorney in Oklahoma.
Okay.
Do you know the value of the property?
The value of the property approximately shows 102, but there's a big push in that area. The property value is is skyrocketed in that area.
Yeah. So let's go over some vocabulary words, and then we'll get back into your specific situation. So estate. So what is an estate? So the way we use it, sometimes people call a large house an estate. That's kind of true. But an estate refers to everything a person owns, whether alive or dead.
Okay.
So this first person, they owned a house, and then we got to figure out what happened to it. So the first person, I want you to see if they had a will. So a will is a document made by a person called a testator or testatrix, is a female. They designate the beneficiaries of their estate, who gets the stuff, guardians if they have minor kids, the personal representative. That's what we call it in Arizona and California. The personal representative is who has authority to act for the name, who has authority to act for the estate.
Okay.
Now this Uncle Sam, this represents probate. So if an asset's titled in the name of the estate, we need the government to appoint this personal representative. That's what the probate process is. So what I want you to do is figure out the value. It's going to be, you have to figure out the value of their whole estate. And in Arizona and California, they have summary. I call it a probate alternative. You can do, it's called a real property affidavit.
Okay.
And so that's reserved in Arizona. The magic number is 100,000 of equity. California, I believe it's 150. But if it has less, if the value is less than that, and in Arizona, it's determined by the property tax records. So the value on the property tax records, if it's below a certain amount, sometimes there's an alternative to probate where you don't have to go through all the process.
Okay.
So what is probate? For this example, it's showing a couple. She passed away. He received the life insurance through the beneficiary, so it doesn't trigger probate. He received the house. So this example is showing there's a bank account left in the name of the deceased. So, but in your scenario, you're dealing with real estate. So the way probate works, if there's a will, it gets admitted. Probate appoints a personal representative. So they issue, it's called a personal representative letters. That shows that this person has the authority to act for the estate. So that's what you need. So you need to figure out how to get the authority in Oklahoma to transfer that property.
Okay.
That's your main issue, right?
Yes.
So probate, it's time consuming. There's steps to it. We have a creditor period, and then in Arizona, it's a 4-month creditor period. I think it's the same in California. So eventually, after you go through those steps, then they can close out the probate. So
Okay.
probate, it means to prove. So prove that it's going to the right places. Okay, so let's go back to the checklist. So do you see what your next steps are?
Yes.
Oops. Okay, so you're going to figure out what controls. And it sounds like there's 2 layers of this. So if the person that you're dealing with, so who you're dealing with, it was their aunts who received it from their parents or something like that.
So I'm not sure exactly the original owner, who that person was in relation to the mother, but the mother passed away 2 years ago and willed the property to the seller, the current seller. And the current seller says she's been paying the property taxes on the property.
Okay, but it's not in mother's name, correct? The title is in the name of the mother's father.
Now I'm not sure who the original owner was to the mother, but that's who the title name is in.
It's in mother's name?
No, the original owner, whoever it was that willed the property to the mother, that's whose name the title was in.
Okay, so you got to figure out more about their estate.
Okay.
The person that the title's in. So what controls their estate? Did they have a will? Yeah, it sounds like they had a will. They're saying that there's a will that gave it to the other person.
There was a will, according to the seller, there was a will that left the property to her mother, and then her mother, when she passed, she left the will, leaving the property to her.
Okay, so gather those documents, figure out who the fiduciary is. So if those wills name someone to act, that's who you want to deal with, right? You want to figure out who's going to have the authority. Okay. And a lot of times, the person that calls you or gets you involved is not this person. Maybe they're the motivated one, but they, so get the will, see if there's a person named there. Now, if the person that's named as the fiduciary, the personal representative, if they don't want to serve, it's possible that they can resign and appoint someone else.
Okay.
But it's a good idea that if you go to them, or you can start with the attorney. I would get as many facts as you can. From your seller. Get these wills. Get all of that information.
Okay.
And then, contact an attorney in your market. So this is good. This is a chance for you. Call it to date an attorney, right? Show them how you can add value.
Yeah.
To their probate practice. You want to show them how you're going to make this really easy for them. So for attorneys, the deals that they like is the legal work, right? So bring in a client that needs legal work, and they're going to like you if you bring them all these facts, right? So if you call and talk to an attorney in Oklahoma, this is what they're going to want to know.
Okay.
So if you have this information ready, they can give you more information on that initial meeting or initial phone call.
Okay.
And then you'll figure out who you have, who has the authority, and how they get that green fiduciary hat is what I use. Figure out what is the process to get someone appointed.
Okay.
So, and then so if there's a will, my other steps I give is follow the instructions. So we're going to figure out what's controlling, what assets are out there, and then you're going to follow the will if there is one. If there's no wills, then you follow the state laws, the laws of intestacy. I'll see if I can upload it in the YouTube part of this video on Mont Legal. So I want everyone that's watching this, I want them to go to the Mont Legal YouTube and subscribe there. So I'll be doing more content there for real estate investors, and that's also where I teach attorneys and the general public about probate and these topics.
Okay.
So, but I'll put either in this video or I'll get them to paste a post. But this is that outline for the successor trustee or personal representative. So this is good for you to follow. You know, whenever there's, you know, someone that's passed away, you can look at that information. The other
Right.
thing, so this is the death of the loved one checklist. So this is a tool, just some practical information. So, you know, this situation, it sounds like they've been dead a couple of years, so they're probably taking care of these things. But if you're knocking doors or cold calling and find someone where there's we call it a fresh, or, you know, I don't know a better way to say it, you know, someone's recently passed away, this is some practical things. So that's how this tool is designed to be used. You know, sorry for your loss. You know, here's, you know, some practical things you can be doing. And then this longer piece is a memo on fiduciary duty. So this kind of gives into more of the details on how to administer an estate. You know, so for the one that's in charge of that, these are the things that they should be doing. So for my legal clients, I when people hire us, my law firm, to represent them as the trustee, or if they're the personal representative, I give them some version of this. And basically we do all these things for them, but, you know, prepare an inventory of the assets. They need to safeguard the assets. You know, they're gonna be careful how they're investing trust assets. This is all the, you know, just this kind of the CYA, you know, you're telling them everything they should be doing.
Got you.
Trust accounting. But I wanted to provide this for you guys to use out there, you know, because this is this is what I use. So, you know, this outline is where you can start, you know, figuring out what to do, figure out players, what controls. So you're still in this mode, right? For this deal, you got to figure out what's controlling.
Okay.
And then figure out who the fiduciary is.
Okay.
Because they're the one that's going to be able to sign the contract. So that's who you want to be dealing with.
So I actually have a contract signed, but it might not even be binding if they're not the fiduciary.
Correct. That's I would agree with that. I don't know if it's going to be binding if they don't have the authority for the estate. So that's why you want to go to that person, and then you'll get the authority.
So they need to go to get authority for the state if they don't have it.
Right. And the way they would have it, you know, so if they were appointed as a personal representative of the estate through the court, or see in Oklahoma, your jurisdiction, if it's possible to transfer property without probate. It's called a real property affidavit.
Okay.
And then, you know, just realize there's going to be some sort of cost for this. You know, I would communicate this to the seller. You know, make sure they understand. You know, someone's got to get the authority for the dead person, right? You know, they're not here to sign. You know, so there's going to be some work involved, you know, in order to get them that authority. And that's the value that you bring to the deal. You know, if you put together the pieces for them, you know, if you connect them either to an attorney that can get that done, and it may be possible to pay the attorney out of your deal.
Yep.
You know, the attorney just has their local laws and all of that stuff, and disclosures and duty of confidentiality and, you know, things like that. But saying bring this client to the attorney, and they'll help you close your deal.
Okay.
And then that's a good way to meet attorneys in your network, in your area.
Okay.
And then what you want out of this, so this is a chance for you to show this attorney and law firm, you know, how easy you make it for them. Meaning you bring clients who need legal work, do the groundwork, you know, like track down the will, the documents, things like that.
Okay.
And, you know, sometimes attorneys need help. They need someone to go to the property, like do an inventory of it, you know, things like that. And then I always like to liquidate properties as an attorney. You know, it's easier to split cash with 5 people than a house. So they like the solution of liquidating it. depending on how many beneficiaries there are, how many people are entitled to receive from the estate or from the will, that's everyone that they're accountable to.
Gotcha.
So when there's more beneficiaries, they have to make sure they got a fair value for the estate. It's easier when it's a single person. If it's only one beneficiary, and then as long as they're good with the price, then that's what matters.
Okay. And we actually, again, we actually agreed on the price. I sent the contract to the title company for them to open escrow. So what would you suggest in that case? That we need to try to do an addendum to extend it because the contract terms is 30 days?
Yeah, you'll probably need an addendum, but you're gonna need to figure out who has the authority to get it done.
Got you. Okay.
So I would work on that so you have the solution.
Okay.
And you'll figure out what your options are in Oklahoma, to see if it's possible. 30 days, like just recently.
From yesterday.
Okay, so yeah, you got some time in there. So figure out who's in charge, who the fiduciary is, and see if it's possible to get it done within the 30 days.
Okay.
And if not, then you can do the addendum. But I would do a little research first before you get that addendum.
Is there a possibility, depending on Oklahoma law, that this would not have to go through probate?
Yeah, that's a possibility.
Okay.
In Arizona and California, the way those real property affidavits work is you have to file them with the court, though, and wait for the court to approve it.
Okay.
So that's why I'd recommend reaching out to an attorney in Oklahoma that can tell you exactly how it goes.
Okay.
Like I know how long it takes to get a probate through in Arizona and the different options. So
okay.
Like in Arizona, the real property affidavit. So if this was Arizona, this property in your situation, if it's less than 100,000 is what we're dealing with, we could do that real property affidavit.
Okay.
You have to get the right people to sign it, and then you file it with the court, and then it sits there for 2 to 3 weeks is what we're seeing in Maricopa County, Arizona, how long it takes for things to get approved.
Okay.
So an attorney in Oklahoma can give you an idea of what their timeline is like, and I would try to have good solutions before you go back to your seller.
Okay.
You know what you need to do and what the path is to the end.
Okay, and I know an attorney. I don't know if he does probate, but if not, he can point me in the right direction. Yeah, that'd be a good place to start. Okay.
So, all right, Derek. Well, good luck to you. I guess let us know in the Facebook group how things go, so we can know how it goes. And then you have my info. If you need any more help from me, you can reach out, and
okay.
we'll we can keep recording and sharing for the Sub-2 family and everyone, so they can learn from your experience as well.
Yep. Well, I appreciate you, Rilus, for taking time out to talk to me, and I also want to thank Pace for putting this together for us.
Yeah, you're welcome. And shout out to Pace. You offer, I think you said Pace offered to pay for our time if we recorded it.
That's right. Yeah.
He's already paid for it. His team put my Mott Legal branding on these tools. So thanks Pace and Reagan. I don't know. I think it was Reagan that did it. So thank you guys for doing that. So they've already paid it forward for the session is how I viewed it. Thanks for offering that though.
Well, Pace, he's a go-giver, and he just give and give and give and give, and I appreciate him, and everybody else in the Sub-2 family appreciates him, and he's a good example to follow. Yeah, me too. He's definitely a good example. So I aspire to give as much as he does. So yeah. So, all right, Derek. Good luck. We'll talk to you later. All right, Rilus. Thank you. Bye.